Subscribe to our channel and press the bell icon so that you never miss any video lesson from Rao's IAS Study Circle.
Hello everyone, welcome to Rao's IAS Study Circle. In this video, we shall analyze the Indian Polity and Governance section which was asked in the UPSC Prelims examination conducted on 4th October 2020. Now, in general, if we go through the section of Polity and Governance, we see that most of the questions were solvable. However, some of the questions can be said to be on the tougher or rather trickier side. Now, this was because it needed a thorough understanding and conceptual clarity on diverse topics. Now, as we go through this video, you will realize that most of these questions were questions asked from very general topic like judiciary, DPSP, fundamental rights, etc. But the statements which were framed by the UPSC was based on conceptual clarity and thorough understanding not only of the topics covered but also of some of the constitutional provisions. Hence, it's important to understand and develop an approach to study this section of polity and governance. Number one, because it is one of the most solvable part of the paper, and number two, solving these important questions gives you an edge in the competition. So, solving these papers correctly needs conceptual clarity and understanding of these different sections of polity and governance. Now, here I would like to add that you must focus on the basic source, and the basic source would be NCERT books, because NCERT books will help you in developing the background to the relevant topics, and it will also help you to clarify the concepts. And when you go through the constitutional provisions, you'll understand the importance of different topics. So it's important to have a conceptual clarity and thorough understanding not only about the core topics which you generally go through in the polity section, but also of the current affairs section. As we will see, questions were asked on some of the important current affairs topic as well. So by going through these questions, you will realize that how our courses like Daily News Simplified, Focus Magazine, Prelims Test Series, Compass Magazine, QIP classes, etc. helps you in not only developing the concept which is needed, but also to align your thought process with that of the UPSC framework. So on this note, let's start the analysis of these questions asked from the section of Indian Polity and Governance.
Now, as we have already discussed, that understanding the mindset of UPSC is very important, because understanding the mindset of UPSC helps us to decipher the question which is being asked. So in this regard, let us take up this particular question which appears as question number 35 in set B. So the question reads, in India, separation of judiciary from the executive is enjoined by. So UPSC has picked up a very simple idea with respect to separation of legislature, executive and judiciary. However, the emphasis is on the separation between executive and judiciary, and there is a reason behind it. So the question says that in India, separation of judiciary from the executive is enjoined by. Options are A. Preamble of the Constitution, B. Directive Principle of State Policy, C. 7th Schedule, and D. Conventional Practice. Now here UPSC is trying to see that whether you are thorough with this concept of separation of power or separation between the organs of the government, and within the Constitution of India, if this aspect has been discussed at all. Now if you are aware about Article 50, then this makes your job very easy. Separation of judiciary from the executive. It says that the state shall take steps to separate the judiciary from the executive in public services of the state. However, this is not what the question is asking. The question is asking something else. The question is asking that this aspect which is prescribed in the Indian Constitution is provided in which of the following options. Now, since it is in Article 50, preamble as well as 7th schedule, including conventional practice, can be straight away ruled out. Now, for this, you have to know two aspects. One, that the separation of executive from the judiciary is provided within the Constitution. And when I say within the Constitution, I mean within its articles. So even if you don't remember the number of articles, say Article 50, or in which part Article 50 comes into picture, at least you should know that it has been given in one of the articles. And we know that Article 50 forms part of Directive Principles of State Policy. So here you also need to know about DPSP and some of the important provisions of DPSP. Now this can be said to be a comparatively easier question as compared to other questions asked in this examination. Now this is the mindset which UPSC expects from you, and this is the thought process with which we also prepare our students so that they can answer these type of tricky questions. Now, this particular question was asked in the prelims test series in the section of polity. It says that which of the following directive principles were added to the original list of directive principles present in the Indian Constitution. And one of the option was provided as that state shall take steps to separate the judiciary from the executive in public services of the state. Now, this part of DPSP was there since inception of the Constitution of India. So, through this statement, you are also being told that separation of judiciary from the executive has been there in the Indian Constitution since the Constitution came into effect. So, this is how we prepare you about a particular topic, in this case, the DPSP. Now, if we talk about DNS, now this aspect of salient features of judicial independence in the Constitution has been discussed threadbare in the DNS dated 25th February 2020. And as you can see, Article 50 has been extensively explained, especially regarding the separation of judiciary from executive. Now, if you go through the index of this particular DNS, this particular topic was discussed in detail. It mentions about why is an independent judiciary important for democratic country, salient features of judicial independence in Indian Constitution, possible erosion of judicial independence, and standard of conduct, including implementing judicial ethics charter. So we see that the aspect of judicial independence was discussed threadbare. And since such an important topic was covered in DNS, it was also covered in the Focus magazine of March 2020 edition. So in this particular question, you need to know about separation of judiciary from the executive and also the fact that it has been provided in Article 50 of the Indian Constitution, which forms part of DPSP. Now let's take up the next question for discussion, which appears as question number 28 in set B. So this question is also with respect to part 4 dealing with directive principles of state policy. So we understand that the provisions of directive principle of state policy is very important, especially with respect to the Indian Constitution. And the question is also with respect to the provisions of the Indian Constitution, as it says that with reference to the provisions contained in part 4 of the Constitution of India, which of the following statements are correct? Now see, they are directly telling you about part 4 without mentioning about directive principles of state policy. So the first statement is that they shall be enforceable by courts. The second statement is they shall not be enforceable by any court. So the first two statements are in contradistinction with each other. So here it's very simple that either of these two statements are correct. And the third statement says that the principles laid down in this part are to influence the making of laws by the state. So the only question which remains, and the very basic question with respect to directive principles of state policy, is that whether DPSP is enforceable or not. Now, if you have gone through the very basics, not only in NCERT but through any other source, then you know that fundamental rights are enforceable, whereas directive principles of state policy cannot be enforced as a policy measure of the government of India. And these provisions only or merely acts as guidelines for the government to legislate policy on welfare measures for the citizen of India. So we understand that they shall not be enforceable by any court in India, and the principles laid down in part 4, that is DPSP, is to influence making of laws by state. So the first option becomes incorrect, whereas the second and third option becomes correct. So the question was select the correct answer using the code given below. So here the correct answer becomes D, that is 2 and 3. Now, this is a very basic concept with respect to directive principles of state policy, including its justiciability. And this aspect has been covered in the NCERT book of political science, namely Indian Constitution at Work, which is a textbook for political science for class 11. And under chapter 2, under rights in the Indian Constitution, it mentions about directive principles of state policies. And it says that the constitution framers did not want future governments to be bound by certain policy decisions. Therefore, some guidelines were incorporated in the constitution, but they were not made legally enforceable. And this means that if a government did not implement a particular guideline under DPSP, we cannot go to court asking the court to instruct the government to implement that policy. Thus, these guidelines are non-justiciable. That is, part of the constitution that cannot be enforced by the judiciary. So, overall, the purpose of DPSP includes goals and objectives which a society must adopt, certain rights that individuals should enjoy apart from fundamental rights, and certain policies which the government should adopt. So, there is no compulsion, especially with respect to directive principles of state policy. And based on these concepts, a question was also asked in the prelims test series. The question read, which of the following statements relating to directive principles of state policy are incorrect? So here they were asking you incorrect statements with respect to DPSP. So here the point I'm trying to highlight is that concepts relating to DPSP has been asked in detail even in the prelims test series. Earlier we saw a question which asked which were the original provisions of DPSP and which were the provisions which were added later. And again, concepts based question on DPSP was again asked asking which of the statements were incorrect. Now, important point to be highlighted here is that in one of the explanation for this particular question, it stated very outrightly that the directive principles are non-justiciable in nature, that is, they are not legally enforceable by the courts for their violation. So, if any one of you have gone through the basics either through NCERT or would have solved this particular question asked in the prelims test series, then it would have become easier for you to attempt this particular question asked in the prelims of 2020. So we understand that it's important to have a thorough knowledge and understanding about directive principles of state policy. And this question can be said to be a fairly easy question for a serious aspirant of UPSC. Now moving further, let's take up this question on untouchability. The question says, which one of the following categories of fundamental rights incorporates protection against untouchability as a form of discrimination? So two aspects becomes important here. First is that this question is being asked with respect to fundamental rights. And second, within the aspect of fundamental rights, it is asking you about untouchability. So, what you need to know is that which provision gets covered with respect to untouchability, and this aspect of untouchability gets covered under which of these important fundamental rights. So, the options given here are right against exploitation, right to freedom, right to constitutional remedies, and right to equality. Now, to answer this particular question based on different fundamental rights, you need to have conceptual clarity not only about different important fundamental rights such as right against exploitation, freedom, equality, etc., but also what are the important rights within those rights. For example, if we pick up right to freedom, then you must know that what are the different rights which is available under right to freedom. So here I have taken this extract from the Constitution of India itself, and as you can see, these are the important fundamental rights as prescribed under Part 3 of the Indian Constitution. These are right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, and right to constitutional remedies. So, primarily, these can be said to be the six important fundamental rights provided under Part 3 of the Indian Constitution. Now, regarding this particular question, it deals with untouchability, which forms under Article 17 and hence gets covered under right to equality. So, here the point I'm trying to highlight is that you need to know about these important fundamental rights not only with respect to the right or article itself, and also the fact that these rights gets covered under which of these important six fundamental rights, namely right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, and right to constitutional remedies. So in this case, our answer become D, that is right to equality, as untouchability has been prescribed under Article 17 of the Indian Constitution, which gets covered under right to equality. Now, this aspect has also been covered in the Prelims Compass magazine, which is a subject wise yearly compilation, and it is released just prior to your prelims examination. And as you can see, it covered very specifically about right to equality, covering from Article 14 to 18 and also mentioning about Article 17. Now, similarly, this topic was also discussed in the DNS dated 15 June 2020, where discrimination was discussed in detail. Further, a very specific question on Article 17 was also asked in the Prelims test series in the section of Polity. The question here read that consider the following statements about Article 17 of the Constitution. So, the statements with respect to Article 17 asked in this Prelims test series include: first, this article imposes restrictions on the practice of untouchability on the state only. Second, the Protection of Civil Rights Act 1955 has been enacted to enforce this article of the Constitution. And third, the term untouchability has been defined by the Protection of Civil Rights Act. So the question was, which of the statements given above is are correct? So here what we understand is that you not only need to know about fundamental rights and about untouchability, but also various legislations which the government of India has enacted in order to abolish untouchability in India. So, in the same DNS dated 15 June 2020, we also discussed in detail about Protection of Civil Rights Act 1955 and also various punishments which have been provided with respect to enforcement of untouchability under this legislation. However, this legislation does not define untouchability. Now, if we go through this first question, it says that this article, that is Article 17, imposes restrictions on the practice of untouchability on the state only. No, this cannot be said to be true because this defeats the entire purpose of legislating the Protection of Civil Rights Act 1955. And this can also be ascertained from the fact that this act provides for punishment for enforcing religious disabilities as well as social disabilities. And these religious or social disabilities are definitely practiced in the society. So this legislation prohibits any practice or preaching of untouchability in our society. Second, the Protection of Civil Rights Act has been enacted to enforce this article of the Constitution. Yes, this is correct. And third, the term untouchability has been defined by the Protection of Civil Rights Act. Now, if we go through the definitions provided under Protection of Civil Rights Act, we find that civil rights has been defined, which says that civil right means any right accruing to a person by reason of the abolition of untouchability by Article 17 of the Constitution. And it does not define untouchability, but rather this act provides for punishment for any activity of untouchability. Now, another legislation which you must be aware of with respect to untouchability is the Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act 1989. Now, this act has been enacted to prevent the commission of offences of atrocities against the members of scheduled castes and scheduled tribes, and it also provides for special courts and exclusive special courts for the trial of such offences, and it also provides relief and rehabilitation of the victims of such offences of atrocities. So, this act provides for punishment for offences against atrocities committed against scheduled caste and scheduled tribe, and this act also punishes the activity of manual scavenging. So we understand that we not only need to understand the concept of untouchability as part of fundamental right, but also various legislations which the government of India has enacted to abolish untouchability in its various forms in India. Now next take up this very simple question asked on welfare state. So the question asked by UPSC was, which part of the Constitution of India declares the ideal of welfare state? Now this is one of the most basic thing which we study about the Indian Constitution. Not only about directive principles of state policy, but also the fact about economic and social justice as provided in the preamble of the Indian Constitution. And accordingly, Article 38 clearly mentions about welfare state. So here the correct answer was A. That is, Directive Principles of State Policy, specially under Article 38, provides for welfare state. And this aspect of welfare state, as you can see, was covered very directly in the DNS dated 18th April 2020, where we highlighted about social democracy, about Article 39 of the Indian Constitution, which is a part of DPSP, and also with respect to justice, which has to be social, economic, as well as political. Further, this aspect was also covered in the Prelims Compass magazine of Polity and Governance section, and questions on DPSP was also asked in the Prelims test series. And in the explanation of the Prelims test series, it specifically mentioned about Article 38, which says that it authorizes the state to secure a social order for the promotion of welfare of the people. So this question can be said to be a pretty simple question, and I hope most of you would have answered this question correctly, as it mentions about one of the most basic aspects of the Indian Constitution, that it provides for a welfare state. Now, the next question to be discussed is with respect to session of parliament and the power of the President of India to call for such a session. Now, to answer this question, you need to have clarity about the parliament, its various sessions, and also the powers of president to summon for such a session. Now, regarding parliament, what you need to know is about Article 79. Now, it says that there shall be a parliament for the union which shall consist of president and two houses to be known respectively as the Council of States and House of People. So, basically, the parliament includes three things. Number one, President of India. Number two, Lok Sabha. And number three, Raj Sabha. So, this is what the parliament comprises of: President of India, Lok Sabha, as well as Rajya Sabha. So, this can be said to be the absolute basics about parliament. And because of Article 79, the president gets power to summon the parliament or gets power to summon different sessions of the parliament. Now, regarding the sessions of parliament, you also need to be aware about Article 85. So, if you are thorough with the concept of Article 79 and 85, then solving this question would have become comparatively easier. Let's go through Article 85 first, and then we shall try to understand what these different statements are actually saying. So, Article 85 mentions about sessions of parliament, prorogation, and dissolution. So, it mentions about three things: sessions of parliament, prorogation of parliament, and dissolution of parliament. So, the article highlights that president shall from time to time summon each house of parliament. So, the president can summon both Lok Sabha as well as Rajya Sabha to meet at such time and such place as he thinks fits. So, time and place can be determined by the president. However, 6 months shall not intervene between its last sitting in one session and the date appointed for its first sitting in the next session. Basically, two sessions of the parliament must be held within 6 months. And apart from this condition, there is no other condition prescribed under Article 85 for holding the sessions of parliament. The article further says that the president may from time to time prorogue the house or either house or dissolve the house of people. Now, why only dissolve the house of people? Because Rajya Sabha cannot be dissolved. Now, based on these understandings, let's go through the question asked by UPSC. So, the question was: consider the following statements. 1. The President of India can summon a session of the Parliament at such place as he or she thinks fit. Yes, this statement is correct. Second, the Constitution of India provides for 3 sessions of the Parliament in a year, but it is not mandatory to conduct all 3 sessions. No such thing has been provided under Article 85 of the Indian Constitution. Third, there is no minimum number of days that the Parliament is required to meet in a year. Yes, this is also correct, as no such conditions has been provided under Article 85 of the Indian Constitution. So the question here was, which of the statements given above are correct? So the correct statements are 1 and 3. Hence the answer becomes C. Now on the same thought process, a similar question was asked in the prelims test series. The question said, consider the following statements about the parliament. Number 1, the time period between 2 sessions of the parliament cannot be more than 6 months. Second, the president cannot summon each house of parliament to meet outside the parliament house building. And third, the constitution allows for secret proceedings of the parliament. So the idea on which this particular question was framed in the prelims test series, the same idea was utilized by UPSC to frame this particular question on summoning of parliament and also different sessions of parliament. So in the explanation of this particular question on prelims test series, it clearly stated about Article 85 which we have just discussed. And regarding the secret sitting of the parliament, it highlights that secret sitting of the parliament can be called by speaker or the chairman of Rajya Sabha, that is speaker of Lok Sabha or the chairman of Raj Sabha. However, this aspect has not been provided in the Constitution of India, but provided in the respective rules of the House of Lok Sabha and Raj Sabha. So based on these information, options second and third becomes incorrect. So here the correct answer was A. So these are the concepts on the functioning of parliament which we cater to you even in our prelims test series. So the point here is that we need to have a clear concept and clarity about the functionings of parliament, including the role of president under Article 85 of the Indian Constitution. So to answer such type of question, you need to be thorough about constitutional provisions with respect to the functioning of parliament. And this can be said to be a concept based question. Now, the next question to be taken up is also with respect to Rajya Sabha. Now, this question may appear to be simple, but it is tricky because it involves a lot of conceptual clarity on your part. Let's go through the options and try to understand what are the different conceptual clarity which is actually needed to solve this particular question. The question is Rajya Sabha has equal powers with Lok Sabha in the following matters. So, a question based on comparison has been asked by UPSC, that is, between Raj Sabha and Lok Sabha. And this question is almost in the same lines with respect to comparison between fundamental rights and directive principles of state policy. So, the question is that Rajya Sabha has equal powers with that of Lok Sabha in A. The matters of creating new All India services. Now, regarding the first option, you need to be very clear about Article 312 of the Indian Constitution. Unless and until you are aware about Article 312 of the Indian Constitution, it will be very difficult for you to solve this particular question. So, Article 312 mentions about all India services, and it says that if the Council of States, that is Raj Sabha, has declared by resolution supported by not less than two-thirds of the members present in voting, and it is also necessary or expedient in the national interest so to do, Parliament then may by law provide for creation of one or more All India services. So with respect to creation of All India services, Raj Sabha clearly has the upper hand, and Lok Sabha and Raj Sabha does not enjoy similar powers. So the first option can be ruled out. Second, amending the constitution. Now here we are discussing about Article 368 of the Indian Constitution. Now again you have to be very clear about the provisions of Article 368. So Article 368 basically provides for power of parliament to amend the constitution and procedure therefore. And clause 2 of Article 368 says that an amendment of this constitution may be initiated only by introduction of a bill for the purpose in either house of parliament. So both Lok Sabha and Raj Sabha enjoys similar power with respect to constitution amendment bill. Hence this option seems to be correct so far. However, let's go through options C and D. Removal of the government. Now in this regard, you need to be aware about Article 75 clause 3 as well as no confidence motion. And if you are aware that a no confidence motion can be introduced only in Lok Sabha and not in Rajya Sabha. So here again, this option can be ruled out. Further, making cut motions. Now, cut motions is associated with demand for grants. And demand for grants is presented along with budget and is voted only in Lok Sabha. So regarding cut motions which are expressed as signs of dissatisfaction against the government, it can only be voted in Lok Sabha and not in Raj Sabha. So here again, Rajya Sabha does not enjoy equal powers with that of Lok Sabha. So these are the conceptual clarity which you must have while answering this particular question asked on Rajya Sabha. Now, based on this concept, a similar question was again asked in the prelims test series. The question was, consider the following statements about Rajya Sabha. First, Raj Sabha has equal powers to Lok Sabha in respect of Constitution Amendment Bill. Now here again it is mentioning about Article 368 of the Indian Constitution. The same idea with which UPSC has formed this particular question on the Rajya Sabha. So understanding about a topic becomes important, and it is more important than solving the right answer, because if you are thorough with the concepts with respect to functioning of Raj Sabha as well as Lok Sabha, then you can solve similar or any other question asked by UPSC in near future. The second statement asked here was that all UTs have representation in Raj Sabha. And third, the resolution for removal of the vice president can be introduced in the Raj Sabha only. Now this point has been highlighted very clearly in the explanation of this PTS question, where it says that all UTs does not have representation in the Raj Sabha. and the resolution for removal of vice president has to be initiated only in Rajya Sabha. So here in this particular question, the correct answer was C, that is 1 and 3 only, based on the understanding of functionings of Rajya Sabha. Now, this topic was also covered in the DNS dated 19th November 2019 when the news appeared with respect to 258th session of Rajya Sabha. And this topic was also covered in the Focus magazine of December 2019 edition. Thus, it is important to have conceptual clarity not only with respect to functionings of Rajya Sabha but also with respect to Article 312, Article 368 of the Indian Constitution, and also with respect to the functioning of demand for grants. Now let's take up our next question on preamble to the Constitution of India. Now preamble is a very important document in the Constitution of India as it contains the enacting clause which brings the Constitution into force. It declares the rights and freedoms which people of India intends to secure for all its citizens. It declares a basic type of government and polity which is to be established in India, and it also throws light on the source of the constitution, that is, we the people of India, as highlighted in the preamble to the Indian Constitution. Now, as you can see, that preamble of the Indian Constitution starts with we the people of India having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, liberty, equality, and fraternity. So, based on these ideals of the preamble, let's go through this particular question. The question says that the preamble to the Constitution of India is, options are a part of the Constitution but has no legal effect. So, this question is asking two aspects regarding the preamble to the Indian Constitution. That is, whether the preamble to the Indian Constitution is a part of the Constitution and whether the preamble to the Indian Constitution has any legal effect. So, without having a basic understanding about these two aspects, you will not be able to solve this particular question asked on preamble. So, although this question may appear to be simple, but it can be said to be a tough question asked on the preamble to the Constitution of India. Now, with respect to the preamble to the Constitution of India, you need to know about the Berubari case as well as the judgment given in Kesav Nanda Bharati case, which also gave the famous basic structure doctrine. Now, one of the most important aspects of Berubari case was that it described preamble to the Constitution as a document which serves as a key to open the minds of the framers and also shows the general purpose for which they made the several provisions in the Constitution. However, the Berubari case held that preamble is not a part of our Constitution, but this part of the judgment in Berubari case was overruled in the Kesav Nanda Bharati judgment, and it highlighted that preamble to the Constitution of India is a part of the Constitution. However, preamble is not a source of power nor a source of limitations, and preamble has a significant role to play in the interpretation of statutes, also in the interpretation of provisions of the Constitution. So from here we understand that preamble alone does not have any power but provide the guiding principles which was envisaged by the constitution makers. So from this perspective, this option seems to be correct. However, let's go through the other options as well. B. It is not a part of the constitution and has no legal effect either. Now this option can be straight away ruled out as Kesav Nanda Bharati judgment clearly stated that preamble is a part of the constitution. Next, a part of the constitution and has the same legal effect as any other part. No, it does not have the same legal effect. And D, a part of the constitution but has no legal effect independently of other parts. Now this aspect becomes more interesting, and when we compare the options between A and D, the fourth option, that is D, seems to be more appropriate. So in this, the correct answer becomes D. That is, the preamble to the Constitution of India is a part of the Constitution but has no legal effect independently of other parts. Now, these ideas were also asked in the full length test of the prelims test series regarding the preamble. The questions say that with respect to the preamble to the Indian Constitution, consider the following statements. Number 1. It was enacted before the rest of the Constitution so that it can provide the broad guidelines to which Constitution should adhere. No, this statement is incorrect. Second, it does not act as a prohibition on the arbitrary powers of the legislature because it is not a part of the Constitution. Now we know that it is a part of the Constitution, hence it is also incorrect. Third, it has been amended only once so far by the 44th Constitutional Amendment Act 1978. No, this statement is also incorrect as it was amended by the Constitution 42nd Amendment. And fourth, the original preamble did not contain the words socialist, secular, and integrity. Now, this statement is correct. So, the question was which of the statements given above is are incorrect? So, the incorrect statements are 1, 2, and 3. Hence, the correct answer here was 1, 2, and 3. So we understand that this aspect of preamble not being a part of the constitution or being a part of the constitution was also asked as one of the statements in the full length test of the prelims test series. And accordingly, even in the explanation, this aspect of Kesav Nanda Bharti case was highlighted. It mentioned that though the preamble is neither a source of legislative power nor acts as a prohibition upon the powers of the legislature, it is an integral part of the constitution as was upheld in the Kesav Nanda Bharti judgment. So we understand that this topic of preamble is very important and we must have a thorough understanding of the topic in order to solve questions asked either in the prelims examination or in the mains examination. Now let's take up question number 23 in set B. Now this is a very important question asked by UPSC based on basic structure and judicial review. Now both these topics of basic structure and judicial review are some of the most important concepts in the Indian polity section of UPSC examination. So in this regard, you must have a thorough understanding of basic structure as well as judicial review. Now first of all, let's go through the question as the question seems to be very tricky with respect to its formation of statement. Number 1, it says that the Constitution of India defines its basic structure in terms of federalism, secularism, fundamental rights and democracy. Now here UPSC wants to trap you in understanding the basic aspects with respect to basic structure, namely federalism, secularism, fundamental rights and democracy. So it is possible that you may be trapped with respect to these aspects of basic structure. However, the most important word mentioned in this statement is define. Now you have to know whether the Constitution of India defines basic structure or does not define basic structure. And here in this particular question, you need not know which of the following are part of the basic structure. So even if you know whether the Constitution of India has defined basic structure as one of the provisions or within one of its articles, or the term basic structure doctrine has come from somewhere else, namely through a Supreme Court judgment of Kesav Nanda Bharti case as discussed earlier. Now at the very outset, we all know that the Constitution of India in itself does not define the term basic structure, but rather this term was used for the very first time in Kesav Nanda Bharti judgment, where constitutional 24th and 25th amendment were challenged by a 13-judge bench. So at the very outset we can say that the first statement is incorrect as the constitution does not define basic structure. Now second, the Constitution of India provides for judicial review to safeguard the citizens' liberties and to preserve the ideals on which constitution is based. Now here there is a difference between the term defines and provides for. Yes, the Constitution of India provides for various provisions regarding judicial review. So yes, this statement becomes correct. So here we need not worry about the concept of judicial review or basic structure, but rather we should only know whether these concepts have been defined or provided for in the Constitution of India. Now, so far we have seen the term Constitution of India has been asked repetitively by the UPSC. So, it becomes more clear that going through the important provisions of the Constitution of India becomes very important for our upcoming examination as well, and also to understand the basic concepts provided in these constitutions. So the question asked was which of the statements given above is are correct. So the correct answer become B, that is 2 only, since basic structure has not been defined. Now based on this concept of basic structure, a similar question was asked in the prelims test series. The question stated, consider the following statements about Kesav Nanda Bharti case. So here it did not mention about the basic structure doctrine, rather it mentioned about the judgment which delivered the basic structure doctrine. Statement 1. The case saw the formation of the largest bench in the history of Supreme Court comprising 15 judges. No, this statement is incorrect as it comprised of only 13 judges. Now the question is that why only 13 judges and why not 15 judges? Now it provided for 13 judge bench because Golaknath was decided by an 11 judges bench. And this particular judgment of Kesav Nanda Bharti was reviewing Golaknath case. Hence a larger bench was necessary. So the first statement here becomes incorrect. Second, the court ruled that fundamental rights of the Constitution are amendable without interfering with the basic structure of the Constitution. Now, this statement becomes problematic because we not only need to know what are the important concepts which has been included in the basic structure, but also whether fundamental rights can be amendable under Article 368 of the Indian Constitution. So, in this regard, let us go through some of the important provisions of Kesav Nanda Bharti judgment. It highlighted that power to amend the Constitution is found in Article 368 itself. And Article 368 confers power to abridge fundamental right or any part of the Constitution. Hence, Kesav Nanda Bharti judgment clearly stated that through Article 368, even fundamental right can be amended. However, the judgment held that the Parliament does not have unlimited power to amend the Constitution, and amending power of the Parliament cannot be exercised in a way to emasculate the basic or fundamental features of the Constitution. Now the question arises is, what are these basic or fundamental features of the Indian Constitution? Now these elements of the basic structure was described in detail in the DNS dated 4th February 2019. As you can see, the basic structure includes supremacy of the Constitution, sovereign, democratic and republican nature of the Indian polity, secular character of the Constitution, separation of powers between legislature, executive and judiciary, federal character of the Constitution, unity and integrity of the nation, welfare state, that is socio-economic justice, judicial review, freedom and dignity of the individual, parliamentary system and rule of law. Now further in the same DNS, we also highlighted that the basic structure doctrine finds no explicit mention in the Constitution of India. And this was the exact aspect which was asked by UPSC in its first statement. As you can see, the statement read that the Constitution of India defines its basic structure. So here UPSC wanted to test whether you knew this fact that the Constitution of India does not provide for basic structure, rather it was provided through the Kesav Nanda Bharti judgment. So based on this understanding, the second statement becomes correct. Third, the judgment said that there can be judicial review of constitutional amendments also. Yes, this is also correct. So the question was, which of the statements given above are correct? So the correct answer here become 2 and 3, that is B. Now, as you can see in the explanation of this test series, it mentioned that Kesav Nanda Bharti case, the Supreme Court overruled its judgment in the Golaknath case, and it upheld the validity of 24th Amendment and stated that Parliament is empowered to abridge or take away any of the fundamental rights. However, at the same time, it laid down a new doctrine of basic structure of the Indian Constitution. It further ruled that the constituent power of the Parliament under Article 368 does not enable it to alter the basic structure of the Constitution. So this means that a Parliament cannot take away a fundamental right which forms part of the basic structure of the Constitution. So settling the case of basic structure, let's take up this particular aspect of judicial review. Now regarding judicial review, the question stated that the Constitution of India provides for judicial review. And we know that through Article 32, 226 as well as 13, the Constitution of India does provide for the concept of judicial review. Thus, both these concept of judicial review and basic structure becomes a very important concept, and questions can again be asked in the future regarding both these topics. Now let's take up this particular question. Now to answer this particular question, you need to have a clarity of number of concepts. And these number of concepts are very different with respect to statement 1 and statement 2. Now in statement 1, you need to be aware about the age regarding right to vote and also the minimum age for qualifications for state assembly. And in this regard, this particular statement has combined both these information. So let's go through the statement. It says, according to the Constitution of India, a person who is eligible to vote can be made a minister in a state for 6 months even if he or she is not a member of the legislature of that state. Now again the term Constitution of India has been mentioned in the question, and accordingly you need to be aware about the constitutional provisions regarding both these concepts. So Article 326 mentions about elections to the House of People, that is Lok Sabha, and to Legislative Assembly of every state shall be on the basis of adult suffrage. That is, every person who is a citizen of India and who is not less than 18 years of age. So we understand that the minimum age for voting is 18 years. However, the same is not with respect to the minimum qualification regarding entering Legislative Assembly or Legislative Council. Now, in this regard, Article 173 says that a person shall not be qualified to be chosen to fill a seat in legislature of a state unless, in the case of Legislative Assembly, he is not less than 25 years of age, and in the case of Legislative Council, he is not less than 30 years of age. So the minimum age for entering Legislative Assembly, Legislative Council, and minimum age for voting are quite different. And accordingly, a person who is eligible to vote, that is, a person maybe of 18 and a half years or even 19 years, cannot enter into Legislative Assembly or even Legislative Council of a state. Hence, the first statement becomes incorrect. Now, let's move to the second statement. Now, it mentions about permanent disqualification from contesting elections if a person is convicted of criminal offense for which imprisonment is 5 years. So the statement reads, according to the Representation of People Act 1951, a person convicted of criminal offense and sentenced to imprisonment for 5 years is permanently disqualified. So the term to be highlighted here is permanent disqualification from contesting elections even after his release from the prison. So again, we need to be aware about the provisions of Representation of People Act in this particular scenario. Now, if we go through the DNS of 18th August 2019, then we see that this provision was discussed under Representation of People Act under section 81M, which said that a person convicted of an offence under Prevention of Corruption Act shall be disqualified for further period of 6 years since his release. So there is no permanent disqualification, rather the disqualification is for 6 years since the release of the person. So for 6 years since the release of a person, he or she cannot contest elections. So again, the second statement also becomes incorrect. So the question was, which of the statements given above are correct? So correct answer becomes D, that is neither one nor two, since both the statements are incorrect. Now on similar lines, again question was framed in the prelims test series in the full length test. The question read, which of the following provisions are correct regarding the Representation of People Act 1951? Now directly provisions from Representation of People Act was asked, and the same was provided in the statement given by UPSC. Statement 1 said that a person imprisoned for at least 2 years shall be disqualified for a further period of 6 years since his release. Yes, this statement is correct. Second, failing to declare electoral expenses within the time leads to disqualification of a candidate. Now this statement also becomes correct. And third, disqualification on ground of corrupt practices are determined by the Election Commission of India. No, any election petition is to be determined by the High Court as per section 80 of the Representation of People Act 1951. So here the question was, select the correct answer using the code given below. So here the correct answer become B, that is 1 and 2 only. Now this aspect of voting right and especially Article 326 was discussed in the DNS dated 19th April 2019 when the news appeared regarding petition in Supreme Court on voting rights of under trials and convicts. And here disqualification for registration in electoral roll and also Article 326 was explained. So this question asked by UPSC was on similar lines which was discussed in prelims test series, DNS videos and the June edition of Focus magazine, which also covered about section 81M of Representation of People Act 1951. Now let's take up the next question on constitutional government. Now to answer this particular question, you need to have a clear understanding of the concept known as constitutionalism. Now in simple words, constitutionalism refers to limited government or a government limited by constitutional norms or provisions. Now, if we think about Indian Constitution, then we understand that it not only provides for certain rights but also limits powers of the state. Further, it also provides for separation of powers between legislature, executive, as well as the judiciary. So, based on this understanding of constitutionalism, the question was a constitutional government by definition is a. Options were A. Government by legislature, B. Popular government, C. Multi-party government, and D. Limited government. So, here the correct answer becomes D, that is limited government. So, as already discussed, this idea of constitutionalism is often associated with political theories of John Locke which believes that the government can and should be legally limited in its powers, or rather restrained in its powers, and that the government's authority or legitimacy should depend on its observing these limitations provided through a set of norms which is generally contained in the constitution of that country. So overall we can say that constitution consists of set of norms or rules which creates structures and also possibly defines the limits of the government power or authority. And the same aspect can be said about the Indian Constitution as well, as it defines the jurisdictional boundaries of different organs of the government. It provides for a set of rights declared as fundamental right which cannot be taken away at will by the state. However, state can impose certain reasonable restrictions based on defined criteria provided under Article 19 Clause 2. Now, these aspects of reasonable restriction was also discussed in the DNS dated 9 September 2020 in the article named Demonization of Dissent. Further, the concept of constitutional morality was also discussed in the DNS dated 21st September 2020. So, based on these understanding of constitutionalism and Indian Constitution, we can say that a constitutional government by definition is a limited government. Now, the next important question is based on parliamentary system of government. So, the question very simply asked was a parliamentary system of government is one in which. Now, regarding parliamentary system of government, you first of all need to be aware about Article 75 Clause 3 and also the fact that in a parliamentary system of government, the executive is responsible to the legislature and the legislature can ensure accountability from the executive by asking various questions in the parliament. So, Article 75, Clause 3 says that the Council of Ministers shall be collectively responsible to the House of the People. So, the options regarding the parliamentary system of government includes. Now, regarding the first option, in a parliamentary system of government, all parties are not represented in the government. So, option A becomes incorrect. Option B, the government is responsible to the parliament and can be removed by it. Yes, this is true by ensuring a no confidence motion in the House. So this option becomes correct. However, let's go through the other option as well. C, the government is elected by the people and can be removed by them. No, the people cannot remove the elected government. And C, the government is chosen by the parliament but cannot be removed by it before completion of a fixed term. No, this again becomes incorrect. So the correct answer here was B. Now, this aspect of parliamentary government was discussed while discussing the various parliamentary reforms in the DNS dated 30th October 2019. The news highlighted that parliamentary government revolves around the consent of the people through elected representatives. Further, it says that parliament is an instrument for expressing public opinion, voicing public grievances, and also restraining the executive and ensuring responsibility and accountability to national sentiment and will. Further, different types of questions raised in the parliament was also discussed in the DNS dated 4th September 2020, as these are the various tools through which the legislature ensures accountability from the executive. Now, in the same DNS, previous year's question asked by UPSC on the same theme, namely the parliamentary system of government, was also discussed in the same DNS. As you can see, a question asked in 2015 was almost similar, as the question was there is a parliamentary system of government in India because options were the Lok Sabha is elected directly by the people, B. Parliament can amend the constitution, C. Raj Sabha cannot be dissolved, and D. Council of Ministers is responsible to the Lok Sabha. So here the correct answer was D. And this aspect of accountability in a democracy and also parliamentary reforms was also covered in the October 2020 edition of Focus magazine. Thus, we see that number of questions in the past have also been asked by UPSC on the concept of parliamentary system of government. Now, let's take up question number 25, which discusses about bureaucracy. Now, the question asked by UPSC was that in the context of India, which one of the following is the characteristic appropriate for bureaucracy? So, the question was very specific regarding the appropriate for bureaucracy in the context of India. Now, options were A. An agency for widening the scope of parliamentary democracy. B. An agency for strengthening the structure of federalism. C. An agency for facilitating political stability and economic growth. And D. An agency for the implementation of public policy. Now, we all know that in this, the correct answer was D. And this question can be said to be a comparatively easy question asked in the context of Indian bureaucracy. Now, issues regarding Indian bureaucracy and civil servants was discussed in the DNS dated 11th August 2020, where various challenges pertaining to Indian civil servants were discussed. And one of the major challenges which was discussed was the inaccessibility of the civil servants, namely the district magistrate and superintendent of police, with respect to the public to avail government schemes and policies. And it was also discussed that these officials do not cater to the poor section of the society, especially with respect to implementing government policies. In the Focus magazine of December 2019, we discussed about Pragati, which is a multi-purpose and multimodal platform which addresses common man's grievances and also monitors and reviews important programs and projects of the Government of India as well as projects of the state governments. Further, the aspect of journey of civil services in India was also discussed through part 1 and part 2 in the March as well as May 2019 edition of Focus magazine. Thus, this idea of bureaucracy was discussed in detail, and hence this question can be said to be one of the simple questions asked by UPSC in the prelims of 2020. Now, next, let's take up this particular question asked with respect to Universal Declaration of Human Rights. These can be said to be certain trickier question. Now, here you need not remember every principles of UDHR or Universal Declaration of Human Rights. Rather, you must have a basic understanding about UDHR and the kind of rights which are prescribed therein. So, in this regard, let's go through this question first. It says, other than the fundamental rights, which of the following parts of the Constitution of India reflect or reflects the principles and provisions of Universal Declaration of Human Rights? So it's saying that other than fundamental rights, which of the following can be said to be a reflective of UDHR? Now options are 1. Preamble, 2nd. Directive principles of state policy, and 3rd. Fundamental duties. Now while attempting this question, you might feel confused that which part of Universal Declaration of Human Rights are prescribed in preamble, DPSP, or even fundamental duties. Now, since this is a concept based question, so generally UDHR is a very comprehensive set of rights, and preamble, directive principles of state policy, and even the fundamental duties more or less contains most of the principles reflected in Universal Declaration of Human Rights. So in this, the question was select the correct answer using the code given below. So yes, the correct answer here was D. Now, this chapter on importance of fundamental duties was covered in the August 2020 edition of the Focus magazine. And as you can see, this aspect of UDHR was prescribed with respect to about fundamental duties. It said that fundamental duties were added in the Constitution on the recommendation of Sardar Swaran Singh Committee, and the insertion brought Constitution of India in line with Article 29(1) of UDHR. So clearly fundamental duties is a correct option. Some of the important aspects of preamble such as freedom, equality, liberty can be found in the initial articles of UDHR. Whereas Article 23 mentions about right to work, free choice of employment, just and favorable conditions of work, and protection against unemployment. Now some of these aspects can be found in the directive principles of state policy, including Article 25, which mentions about right to a standard of living adequate for the health and well-being of himself and of the family, including right to food, clothing, housing, medical care, etc. And it also mentions about, and Article 26 mentions about that everyone has the right to education. So we understand that principles of UDHR is reflective in not only in the preamble, DPSP, and fundamental duties, but also in the fundamental rights. Now let's take up question number 36 asked with respect to the macroeconomic framework statement. Now this question can be said to be fairly easy if you are aware about not only the constitutional principles but the documents which are laid in the parliament by the finance minister during the presentation of the budget. Now the question said that along with the budget, the finance minister also places other documents before the parliament which include the macroeconomic framework statement. Now, this aforesaid document, that is the macroeconomic framework statement, is presented because this is mandated by. Now, here, this question is testing not only your understanding about the constitutional provisions regarding budget, but also other provisions, namely the FRBM Act or the Fiscal Responsibility and Budget Management Act. Now, technically speaking, this question can be said to be part of polity or even economy. However, this question has been framed regarding the constitutional principles. We have taken up this particular question in our discussion in the section of polity and governance. So, in this regard, the options provided were A. Long-standing parliamentary convention, B. Article 112 and Article 110 Clause 1 of the Constitution of India, C. Article 113 of the Constitution of India, and D. Provision of the Fiscal Responsibility and Budget Management Act 2003. So, since I have given you a hint regarding FRBM, so here the correct answer become D. Now, generally, you must know the documents which are presented by the finance minister when the annual financial statement is laid in the House of the People. So, regarding this list of budget documents was discussed in the Union Budget discussion of 2019-20 and also mentioned during the Union Budget discussion of 2020-21. So this aspect of list of budget documents was discussed here where it mentioned about various statements mandated under FRBM Act which included macroeconomic framework statement and medium term fiscal policy cum fiscal policy strategy statement. Now the purpose of FRBM was also provided you in the PDF when on 2nd February 2020 we discussed about the macroeconomic vision with respect to the budget. And these were the important topics which were discussed along with the discussion of budget on that particular day in the DNS. So while studying about budget, you must focus on constitutional provisions, important documents, and also FRBM Act. Now let's take up the next question on MPLATs. Now this question can be said to be fairly tough because the statements which have been framed in this question have been taken up from the guidelines of MPLAT scheme. However, there were few points which we also in the DNS video did discuss. Let's go through the question first. Now it says that with reference to the funds under MPLATs, which of the following statements are correct? Statement 1. MPLATs must be used to create durable assets like physical infrastructure for health, education, etc. Second, a specified portion of each MP's fund must benefit the SC/ST population. Number 3. MPLATs funds are sanctioned on yearly basis and the unused funds cannot be carried forward to the next year. And fourth, the district authority must inspect at least 10% of all works under implementation every year. Now, by going through these provisions, we understand that these are definitely tough provisions and it might not have been easier for most of you to answer this kind of question. So the best option here is to leave such question unless and until you are sure about this. Now, as I've already mentioned that we did discuss about MPLATs and a very significant aspect which was discussed here was that funds under MPLATs are non-lapsable. That is, they can be transferred to the next year. And this aspect of MPLAT was discussed on 5th May 2020. Now, this news on MPLATs also appeared on 7th April 2020 and some other important aspects was also covered regarding MPLAT. So yes, statements were not framed as what we had discussed, but definitely a question on MPLAT was asked by UPSC. Now coming back to the answer of this question, if you could remember that statement from the DNS that MPLAT funds can be carried forward, then you could have easily ruled out statement 3. In this, the correct answer was D, that is 1, 2 and 4 only. So here we understand that statement 1, 2 and 4 were correct. And if you go through the guidelines properly, then you can see that the district authority have to inspect at least 10% of the works under implementation regarding MPLATs and the district authorities have to earmark certain funds for scheduled caste and scheduled tribes. And yes, the MPLAT funds must be used to create durable assets like physical infrastructure for health, education, etc. So the correct answer in this particular question becomes D. However, as said, this question can be said to be one of the tough question asked by UPSC. Now regarding the last two questions, one was on legal services authorities and the other was on Aadhaar. Now both these questions can be said to be extremely factual and requires factual information to solve both these questions. Now I could have easily left out these questions as there were other questions in the section of Polity and Governance which you could have attempted.